Okay, today we're going to be looking at self-defense. So we're looking at chapter 3 in your blue book, chapter 6 if you're using the text. One of the big things that we're looking at with self-defense and defense of others, defense of property, is that the defendant is going to admit that they actually committed the act. And what they're going to say is that, yes, I was involved in some type of force, but the force I used was legal, and then they're going to give a reason. So as we work our way through, think about this. The defendant in the case is going to say, yes, I did it, but this is why, and that makes it okay. When we look at self-defense, we want to consider, what both parties did. For a true self-defense, the one that defended themselves should have no involvement in the actual act. They should have only been defending themselves. And that can be an issue sometimes, especially as we get into calls for service if we go into law enforcement. So the chapter that we're looking at as far as the blue book is going to be chapter 563. I provided the link on your PDF copy of this lecture. So we're going to let you read the learning objectives on your own. One thing that I want to suggest to you, and this is from Police One. If you don't go to Police One, I would suggest you start doing that. And there's several other websites other than Police One. But there's a lot of very interesting stories and lessons and crucial information that you need to be looking up as part of your criminal justice education and career. These are some top cases dealing with use of force. So Graham v. Connor and Tennessee versus Garner we're going to go with today as part of this lesson. But Terry versus Ohio. When you think about Terry versus Ohio and the officer confronting the individuals that he thought were going to do a robbery, he used force in that situation. And then working your way through all of these. It helps to see what the courts see, and then you can make your decisions much easier when you get out on the street or are looking at these. If you go to law school, maybe they can help you with how you look at who your clients come in and say, this is what I did, or this is what was done to me. So, Fourth Amendment. All things being said, this is what we're looking at as far as today. So the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. So when we start looking at this, the big thing that I want you to look at is unreasonable. Searches are okay. What the courts have said, though, is unreasonable searches are not. And so when we look at exigent circumstances, exigent just means, emergency situation, that in certain times we can do searches without a warrant. But they're very specific, and that's where you reading your case law and understanding what the procedural rules are will keep you out of trouble when you start pursuing your career. So Fourth Amendment facts, the Fourth Amendment is not violated by an arrest based on probable cause, even though the wrong person is arrested. So this is an interesting statement in that we could arrest the wrong person, but if we have probable cause, and remember your definition of probable cause, facts and circumstances that would lead a reasonable person to believe a crime's been committed, and that a particular person is the one that committed that. Now, there's several definitions you can read, but all of them basically say the same thing. The U.S. Supreme Court ruled that the Fourth Amendment applies to the use of force by a police officer because the Fourth Amendment provides an explicit textual source of constitutional protection against physically intrusive government conduct. So we want to look at that, physically intrusive government conduct. How did the government agent stop what the normal citizen was doing? So the killing of a fleeing suspect is a seizure. So when that officer pulls that trigger and that bullet strikes that individual, that is a seizure as far as the Fourth Amendment is concerned. Whether excessive force was used by police in making arrests would be analyzed under the Fourth Amendment's reasonableness standard. And then based on the Fourth Amendment, police officers may use deadly force when seizing a fleeing suspect when the offense is a felony and the suspect poses a threat to safety. Always have to have that and right there. Start paying attention when you read and something puts that in there, don't just take one half of the statement. Get them both. That way you have everything in there. Because if you shoot a fleeing felon, or an officer shoots a fleeing felon, and the suspect doesn't pose a threat, you have violated that person's civil rights. So, as far as the chapter definitions, 4563, deadly force, physical force which the actor uses with the purpose of causing or which he or she knows to create a substantial risk of causing death or serious physical injury. A dwelling is any building or habitable structure, and we start looking at that when we get into the Castle Doctrine. You can follow again this link, and it will take you to the chapter, and you can start reading all of the definitions as far as RSMO is concerned. I do want you to go through these and read this, especially forcible felony. Any felony involving the threat of physical force or violence against an individual, including but not limited to murder, robbery, burglary, arson, kidnapping, assault, and forcible sexual offenses. So forcible felony is a issue when we start talking about other criminal acts. Self-defense, as far as the text goes, the element to evaluate whether an act of force for self-defense is justified, including the unlawfulness of the other's acts, the necessity to defend oneself immediately. So we could have an unlawful act and it was necessary to defend yourself, but it wasn't an immediate threat, and we don't qualify for that self-defense, so we have to start looking at that. Defense of another, the element to evaluate whether an act of force for defense is justified, including, again, unlawfulness, necessity, immediately, is it reasonable? Good Samaritan laws, laws that encourage people to come to the aid of another. Castle Doctrine, by the word castle, what we mean is the home or the place that you're at that moment, depending on what state you're in. Deadly force, forces, again, likely to causing death or serious bodily injury. So our state statute and our text definition are very, very close. Stand your ground laws, these aren't necessarily recent laws now, but are passed by many states to permit the using deadly force in response to unlawful attack rather than duty to retreat. And I remember when the state of Missouri was a duty to retreat state, that you were expected to leave. So make my day rules adopted by some states to put no limits on use of deadly force by the occupant of a dwelling. So what that law basically means is that if somebody comes into your home, the use of force is justified no matter what it is when that person comes in. Battered woman defense, we'll look at that as far as state statute. Unreasonable seizures, a seizure made under a government officer that is unreasonable under the circumstances and again violates that Fourth Amendment. In loco parentis, basically means in place of the parent. You're going to want to remember that. Any person taking the place of the parent has the duty and responsibilities of the parent and may reasonably discipline a child in their care. So the use of force by one person against another is a violation of criminal law unless some legal justification for that force exists. So that's what we were talking about with self-defense. Legally sufficient reasons generally require proof that the person using or threatening to use unlawful force, the use of force is necessary, and the amount of force used was reasonable. So the other person has to have some type of valid threat. You know, if somebody casually says that, I'm going to hit you or something like that, and another person would not reasonably take that as a valid threat, you can't use that as a justification to respond and say it was self-defense, or I felt that I was, in fear of physical injury or death. No reasonable person is going to accept that, so therefore it's not going to be self-defense or defense of another. Whether or not the use of force is justified depends on the kind of force, the person using the force, and we'll give some scenarios. But again, we want to remember unlawfulness, the acts of others, what were they doing or what were they threatening to do, the necessity, how necessary was it for you to use force, and did the force you use, was it reasonable? If somebody is swinging at you and you shove them away and they fall down, that would be absolutely reasonable. Somebody swinging at you, you knock them down, and they say, I've had enough, and you go ahead and continue with your assault, unreasonable. You have gone from the victim to the aggressor, and hence the suspect at that time. So, Section 3.04 of the Model Penal Code provides that force can be used in self-protection, again, immediately necessary for the purpose of protecting themselves. So, 70-year-old woman, 100-pound woman, 70-year-old, 100-pound woman becomes angry at a 25-year-old, 200-pound man and begins to hit him with an umbrella. What action may the man take to defend himself? And it is the action limited. So we have got a, for lack of a better word, a fairly frail person in a confrontation with a fairly stout person. She began the assault, so she is the aggressor in this case. If you were to respond, who would actually be charged is the person that was actually doing the assault, which would be her. If he were to take the umbrella from her, and that was it, that's fine. She couldn't say anything. And if he, in his statement, said, she became angry with me and she began hitting me. I grabbed the umbrella and I held it till you arrived. As a law enforcement officer, that's pretty much all that you need. Now, if he knocks her away, uses extreme physical force, so let's say instead of just grabbing the umbrella or just stepping away from her, he attacks and causes some serious physical injury to this person, it's going to switch. So the force he used was unreasonable based on the situation. I would suggest that I've provided a link right here to Zimmerman Martin, and this is the Zimmerman Martin shooting, and explore that and see what the courts looked at as far as use of force, or what the jury looked at as far as the outcome of that case. So, lawfulness of force in the self-defense or defense of others. Again, the unlawfulness of the other's actions, the necessity to defend themselves, and reasonableness of the act. So self-defense and defense of others is exactly the same when we start looking. So, Good Samaritan laws. Many states have a Good Samaritan law that encourages but do not require people to get involved when they witness an assault. So Maryland has a statute that says any person witnessing a violent assault upon the person of another may lawfully aid that person being assaulted by assisting in that person's defense. So it gives the person the right to intervene. So under these statutes, a person may use force to protect another only if the threat of violence is occurring or imminent. So Good Samaritan laws actually help reduce the probability of civil cases being brought against someone. So you get involved and somebody wants to sue you later. This may protect you as far as that lawsuit goes. When we start looking at Missouri, we do have a Good Samaritan statute. So you have to read through all of it, and it's quite long. But again, I've provided you that link as far as a Good Samaritan law, physician, surgeon, and then it just works its way through. In good faith, render emergency care or assistance. It's just one of those things that help protect people that are willing to step up and help. So deadly force, again, is likely to cause or is capable of causing death or serious physical injury. Firing a weapon at a person in the use of deadly force, whether the intent is to kill or to wound. I have seen calls over the year where people thought there was a prowler or something like that and went outside and fired a firearm. Okay, if the other person was in the general direction of firing that firearm, that is likely to cause or is capable of causing death or serious physical injury. And the person will argue with you that I was just protecting my property. Well, you can't protect property with the use of deadly force. So the states are pretty clear on that. You can protect yourself or others from serious physical injury or death using deadly force, but you cannot protect property. So when we look at this, the other person that is using that gun and protecting their property as a threat is definitely violating the laws themselves. So a person who is not engaged in lawful activity who is attacked has the right to stand his or her ground. So this is the Florida Stand Your Ground law. 28 other states have passed that, and this will change. It'll go back and forth depending on what the mood of the country is at the moment. So Shelley discovers Tammy breaking into her car. Shelley grabs Tammy and tries to restrain her. To escape, Tammy punches Shelley and runs away. Which person used lawful force? Which person used unlawful force? So if we look at that, so Shelley discovers Tammy breaking into her car. So Tammy, as far as Missouri goes, we could have either a stealing charge or we could have a tampering charge. Shelley grabs Tammy and tries to restrain her. So Shelley does have the right to use physical force to protect her property, and Shelley does have the right to restrain her as long as law enforcement is being called and is going to intervene. To escape, Tammy punches Shelly and runs away. So Tammy has assaulted Shelly. Shelly has not assaulted Tammy in grabbing and restraining her. So which person used lawful force? When I was looking at this case, I would say Shelly has probably used lawful force in stopping Tammy from breaking into her car and then trying to hold her, hopefully till law enforcement comes, as far as that goes. Tammy definitely has been the one that is the violated the laws in this case as far as Missouri goes. So some states have adopted make my day laws. Here is Missouri's. Use of force in defense of persons. We really need to look at as far as when it's not usable. So the actor, if they were the initial aggressor, definitely going to be an issue for them to argue that they was defensive force as far as defensive persons. If they withdraw, they have to effectively communicate that withdrawal. So if you go to a case and somebody attacked another person, they were losing, and they have to say, I give up, stop, I'm done, something like that. Law enforcement officer can be the aggressor, and there's some cases that we are going to be the aggressor just because of the situations that we're put in. The aggressor is justified under some other provision of the law. Under the circumstances, as the actor reasonably believes that the person whom he or she seeks to protect would be justified in using force. Just read through these as far as this goes. What we were looking at, though, is right here. A person does not have a duty to retreat when we read this statute from a dwelling, residence, or vehicle where the person is not unlawfully entering or unlawfully remaining from private property that is owned or leased by such individual. If the person is in another location, such person has the right to be. So we look at these, and this tells us when we go to these cases, if somebody says, I was at one of these locations and this happened, we really need to take this into consideration as far as our decisions that we're going to make. So reading these state laws and reading them yearly is important. We have to understand that each year our legislators can vote and these can change slightly. And if you're not following up, you're trying to use old statutes to enforce what's going on. So you're going to want to follow the link that I provided here and read all of that. State v. Anderson, the court interpreted the Oklahoma statute as intended to remove any requirements that the force used must be reasonable under the circumstances. So, an occupant who reasonably believes the intruder who has wrongfully entered a residence intends to use some force, however slight, is privileged to use any force, including deadly force. That's that make my day statute, where we don't care what the force is. If the bad person enters the residence or enters one of those privileged locations like we looked at under the Missouri statute. Remember, each state is different, so don't think that they're all going to be the same depending on where you go to work. So castle doctrine, again, castle being your house, long been the law that people who have been assaulted in their homes by a trespasser have no duty to retreat or flee, but may stand their ground. So this is very important. The other person says no duty. They don't have to leave. You don't have to leave your residence. That's not the case in every state. Some states says that they do have a duty to retreat. So if somebody were to enter your house and you can go out the back door, that is what you're supposed to do in certain states under certain laws. Not all states. That's why this law has changed. That's why we've heard it in the news so many times. Because a person's home is their castle, that's again where the castle doctrine came from. So, spring gun, another word for that is a booby trap. In most states, this is illegal. Missouri definitely is. This is the part of the statute as far as unlawful use of weapons. So, when the statute says sets a spring gun, what they're saying is that you can't make a booby trap and get somebody. So, let's say you've got a shed that you store stuff in and people keep breaking into it, and you set something in there that is going to injure them. Something's going to fall on them, something's going to spill on them that's going to hurt them as a message to keep people out of there. Well, the second you've done that, you've created a booby trap, which in reality you've created the spring gun, and what you've done is illegal. So battered women and domestic homicides, every year between 500 and 750 women kill men who have abused them. So battered woman can be found in the prisons of every state. And when we look at the National Criminal Justice Reference Center for research, this is what you need to be using, one of the sites. And we start looking at the victims. We can start doing our research as far as who is the victims in these cases. So right here in the U.S., about 1/3 of men and women experience violence by intimate partner during their lifetime. So going through this and seeing where we're having the issues is very important. Again, you as a criminal justice student, you as a criminal justice practitioner, need to be reading the research as far as what we're seeing. Having that information available to you can definitely help as far as when we start making decisions on the cases that we go to. National Criminal Justice Reference Center, again, excellent source of information when we're doing research or we just need to know what's going on. So, battered women and those who allege they were abused are in every state's prison. So, because battered woman defense is not a perfect defense, the person still gets criminally charged and usually there's still a punishment. To lawfully use deadly force in self-defense, a real or reasonable fear of imminent death or great bodily harm must exist. If not, even though abuse has occurred, the woman can be charged with murder. So when we look at this case, this is not the person being assaulted at the moment. This is the person anticipating the assault and using deadly force to stop the anticipated assault. So force used, deadly or non-deadly, is not justified based on unlawful attacks that occurred in the past. Though not a complete defense, the battered woman defense is often called imperfect, and it can reduce the crime from murder to manslaughter as far as that goes. Missouri statute is right here, and it's also in your blue book. You can look those up. So, example of a case after 25 years with an abusive husband. Barbara Sheehan shot him 11 times with his own gun, killing him. And she used that battered woman defense. It's one of those things that, you know, Sheehan was acquitted of the murder charge, but convicted of illegal use of the gun. So she committed a homicide. She killed another person, but using that defense, she was actually only convicted of the illegal use of that firearm. So use of force in defense of property. A person is privileged to threaten, to use, or intentionally use non-deadly force to protect their property. Force may only be used when necessary to terminate the interference. Virtually all states permit the owners of real estate to use non-deadly force. So you forcing somebody off of your property. Again, non-deadly force. You go out with your firearm and point it at somebody and order them off the property. You are using force that could be considered deadly force. Use of force in making an arrest in most states, again, force is unnecessary because people just comply. Most people in my career that I told were under arrest did exactly what I told them. It was a very rare circumstance that people would actually resist arrest. So when we start looking at that, we can anticipate that most people are going to cooperate with us, but every once in a while we're going to run into that situation, especially if alcohol and drugs were involved, that we may have to use some type of force. We can use force to overcome any resistance by the offender, prevent the escape, and then protect officers and others and the prisoner if necessary. So when we start looking at this, authority of peace officers respond outside jurisdictions. That actually tells us what we can start looking at as far as an emergency situation. And I would suggest that you read this. Where this comes into play is you get a request for what's called a mutual aid, and you're needed outside that jurisdiction. Where this comes into play for this chapter is that if you respond and you have to use force, this is where you can understand what you're going to be using it under. As far as Missouri statutes, again, consider the law in your area and not what we do in a regular class, because the laws do change. So, a person must use force in making an arrest in Missouri. One of the things is that you must be right if you're going to do a citizen's arrest. Again, here's our statute. Private person's use of force in making arrests. A private person who has been directed by a person they reasonably believe a law enforcement officer to assist such officer in effecting the arrest. You can read through this. Can use that. A private person acting on his or her own account, subject to the limitations of 3 of this section, use physical force to arrest or prevent the escape of a person whom such private person reasonably believes has committed an offense, and who in fact has committed such an offense. This is where it starts talking about you must be right. If you aren't right, then you could be civilly or criminally and or both liable in those situations. A private person in effecting the arrest or preventing escape of custody is justified in using deadly force only. So this is the only time that you could use deadly force in that situation. And it's fairly self-explanatory. When deadly force is authorized under the chapter, when he or she, again, reasonably, so the state statute definitely matches what we're talking about in our text. When he or she reasonably believes that such use of deadly force is eminently necessary to arrest a person who at the time in his or her presence, means you have to witness it, committed or attempted to commit a Class A felony or murder, or is attempting to escape by use of a deadly weapon. The defendant, which is the person that actually made the arrest, shall have the burden of injecting the issue of justification under this section, which means you who use deadly force and or an accusation is made of a false arrest, you're the one that's going to have to defend yourself as far as this goes. So, use of deadly force, generally speaking, police officers may use reasonable necessary force in dealing with the public, including arrests. Deadly force may not be used by police to make an arrest unless they have a reasonable belief that the person presents an imminent risk of death or bodily harm to police officers or others. Police may not use deadly force merely to stop a fleeing suspect unless the suspect's armed, has threatened the police or others. There's probable cause to believe the suspect committed a crime that caused serious bodily injury. So, the person that has done an armed robbery, somebody's been injured or killed, that's a no-brainer. We can look at that and understand that. But what about the person that is just, a felony stealing? They've walked in, they've stolen something, and they've taken off running. That's just a property crime. So when we start looking at force, is that what's the potential that they could, injure somebody seriously later on before we start using deadly force? Tennessee versus Garner is a great example of that. When we look at that case, officers respond to a burglary. The person in this case runs. They order him to stop. At that time, what the law said is that you could shoot a fleeing felon. And it didn't differentiate as far as property or, injury. It just said shoot a fleeing felon, and that's exactly what they did. And the court turned around and said, no, you can't do that. Deadly force can only be used in situations where there is an imminent threat to public safety. And what they mean by that is not a threat to property. They mean a threat to actual people. So, the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene rather than with 20/20 vision. And then what we're looking at here is the Graham v. Connor case. So when we look at Graham v. Connor, in this case, a person goes into a convenience store, comes out quickly, gets into a car, and pulls away. The officer in the area sees this and makes an assumption that something just happened. Reality is the person that walked in the store was having a diabetic issue. The store was crowded. They couldn't get what they needed. So they went back and got in the car as a passenger left real quick to try to get to another store. But the officer didn't know that. And so the officer pulls them over, and during that investigation, the person is injured. When they filed the suit, the courts looked at it and they said we have to look at what the officer saw at that moment. So this is the current case that we use as far as looking at right now. I have provided a link so that you can read the full case. This is one of those cases that is definitely, as far as a criminal justice student, you need to be looking at and reading and understanding. As far as the facts of the case, I briefly summarized it, but there's quite a bit more. So, Philadelphia using excessive force. I will let you follow that link and then you can look at that. I have provided a link through PERF, which is Police Executive Research Forum, Guidelines, Guiding Principles on Using Force. And this is from March 2016. It is one of those things that, again, especially in our climate today, that you really need to understand and find sources that make it easier for you as future law enforcement or whatever career that you're going to go into in criminal justice to understand when and where it is appropriate to use force. And is there an alternative? Can we de-escalate the situation? Can we just stop what we're doing and step away and let the situation de-escalate itself? So again, kind of a long document, but well worth looking at as far as the situation goes. So driving under the influence. So DWI, every one of us know it's illegal, yet every day we still get cases in the United States where people think it's appropriate to consume alcohol and then get out on the road. All states make it driving under the influence a crime, but can we force an uncooperative driver to submit to a breath or urine test? We do have implied consent that notifies the driver that they are being requested to submit, a sample of their breath, blood, or urine, or however the state tests where they're at. And if they don't do that, there's some type of ramification, which is usually an extended loss of their driving privileges. So as a result, police and prosecutors have begun taking force samples. And while exceptions exist and conditions to have met, courts typically hold police authority to do so, even without a warrant. So Missouri, though, is one of those that we have to start looking at the statute. So 571.010 is the DWI statute. And when we look at the DWI statute, it's pretty simple. A person commits the offense of driving while intoxicated if he or she operates a vehicle while in an intoxicated condition. So does the alcohol affect their driving is what we're looking at as far as intoxication. And then it breaks it down as far as other factors that could be aggravating circumstances in that case. But the actual law is just this line right here. And then it just tells us what class of a crime it is going to be for that point. So we look at a couple cases. Missouri v. McNeely, Supreme Court held the fact that alcohol in the bloodstream dissipates over time is not by itself an exigent circumstance. So you cannot force somebody to give a sample just because the alcohol is eventually going to go away. Schmerber v. California, the U.S. Supreme Court upheld the constitution of taking a sample. So the courts are going back and forth, and again, we need to follow what is in our law. Here are the links to both cases, and you can use your PDF and go right to those and follow up on those cases. So, using force to obtain evidence of drunk driving, reasonable force can be used to compel a suspect to give blood or urine in some cases. Again, it's got to be reasonable, and you need to follow what your your state says, what your prosecutor, and then whatever agency you work for as far as policy. Do not use a textbook to make decisions after you are out working. Use whatever the policy, procedure, and legal guidelines that your agency, prosecutor's offices, and state law says. So as far as handcuffs, chokeholds, ECD, which think of that as a taser, electronic conducted energy device, handcuffs may be used and reasonably used as far as applying them. Chokeholds, this is a really controversial issue right now as far as this goes. And if we look back to July of 1983, even then the FBI was looking at physiological effects resulting from the use of neck holds. And it starts talking about, what happens when we start using chokeholds, carotid restraints, as far as this goes. And they actually did a study, and I realize it's from 1983, but the information is interesting and it's worth the read. And I provided you that link to give you some background as far as where it came from and why these were used as far as our law enforcement history. Taser may be used to incapacitate a suspect, but only if reasonable. Tasers are one of those that, we've heard a lot about over several years. Tasers have been around most of my career, but not always. There was other, less lethal options as far as chemical agents. Another name would be mace, batons, PR-24s, OPNs. We've always had some type of less lethal option, but were they used correctly and were they used in the right circumstances? The question that we have to start asking ourselves. So, use of force in disciplining children. Parents or others who have custody of children may use reasonable force to discipline. Sometimes discipline crosses the line into abuse and neglect, and we start looking at this as a criminal act versus reasonable. All states have laws requiring school officials, health officials, law enforcement to report abuse. That's definitely in our state. The law is called the Mandatory Reporter Law, and when you go into your criminal justice career, more than likely you will be a mandatory reporter. So, because of the threats of lawsuits, many states have prohibited corporal punishment. So corporal just means physical punishment in schools. In the states that continue to permit corporal punishment, schools may use reasonable force to discipline children, but restrictions are in place. So this is Missouri statute as far as child abuse and neglect. And it gives definition. What is abuse? What is mental injury? What is neglect? Physical injury? Serious emotional injury when we start looking at that, and then what is serious physical injury? So a physical injury that creates a substantial risk of death or that causes serious disfigurement or protracted, which just means long-term loss or impairment of the function of any part of the body. So these definitions definitely help us when we start looking at our individual cases. And then it breaks it down further. I would ask that you click the link using your PDF and you go to this section and read those statutes. So reasonable force, under the common law, a parent or a person in loco may use reasonable force. So in place of the parent is what's in loco parentis. Teachers may use reasonable force to discipline children in their charge. Law enforcement officers, neighbors, and other adults who see children misbehave may not discipline a child or children, although they may use reasonable force to prevent damage of property or injury. So yes, they can stop what they're doing, but they can't discipline them. Reasonable force to maintain order may be used by personnel on airplanes, ships, or trains. That's definitely something that we talk about in our current world. Parenting, as far as this goes, click the link and follow this. It's definitely interesting. This is only about 2-minute video, but it talks about discipline throughout the world and then what different cultures accept as reasonable. So that's the end of this chapter. I do have some cases that are after this that I would like you to read, and so you can follow along with that and then click the links and go to them. As far as chapter 3 goes in your blue book, you are going to want to read this. There's going to be a lot of material that's going to be tested on in your chapter test for this out of chapter 3. So justifications, definitely you're going to have to understand those when you start working your way through there. Use of force in defense of person. And then deadly force, you need to understand it's imminent danger of death, serious physical injury, or a forcible felony. So you have to understand what those forcible felonies are. Starts talking about dwellings, residence, or vehicles, where a person can actually defend. And that if you look on page 43, depending on which book you're using, and as far as the blue book, note that a person does not have a duty to retreat from a dwelling, residence, or vehicle if they're lawfully there. So you need to understand that point. Also, battered spouse syndrome is specifically mentioned on page 43, and reading through that as far as Missouri statutes go. Use of physical force in defense of property, and then defense of premises. Premises defined to include any building, inhabitable structure, or any real property. and when we can actually use what force. Deadly force is not justified simply to protect property is very specifically mentioned on page 45. And where we start looking at as far as law enforcement is the bottom of page 45, where it says, note, deadly force may be used against a fleeing felon only where it is necessary to prevent the escape and the officer has probable cause to believe that the suspect poses a significant threat of death or serious physical injury. One of the words that I would look at there is significant. And there has to be something that's going to be reasonable for me to believe that this person, if they get away, is going to injure someone else. And then it talks about our powers of arrest. You definitely need to understand what probable cause is, and we've talked about that in earlier chapters. Certification required as far as backgrounds and qualifications. Again, just read your way through that. Peace officers profiling for traffic stops, what an officer has to do. Then training. Fresh pursuit. Fresh pursuit is definitely one of those situations where we are using force when we are after that person, especially if we're using vehicles. And when we can do fresh pursuit, another word for that would be hot pursuit, and how we can become involved in that and when it can become a use of force issue. Private person's use of force in making an arrest, we've talked about that earlier, but I want you to read through it through your chapter. Use of force to prevent escape from confinement, and then use of force for persons responsible for care, discipline, and safety of others. Especially where it starts talking about parents, guardian, teachers, or other persons entrusted with the care and supervision of a minor, so in loco parentis, or an incompetent person may use physical force on such minor or incompetent when they reasonably believe that the use of force is necessary to promote the welfare of the minor or incompetent or to maintain reasonable discipline in a school. The force is used is not designed to cause or believed to create a substantial risk of causing death, serious physical injury, or disfigurement. So definitely read through that statute. Okay, that is it. I realize we spent 2 weeks on use of force, but I think it's valuable information that will serve you well. Next week we're going to start with chapter 8.